today is about Brexit, and Sir Nicholas Forwood QC is going to be delivering our lecture. He's got a long history of working in competition law, having been called to the English bar in 1970. Then, after practice in London, he moved to Brussels in 1979 to set up a new chambers specialising in EU and competition law. Then, in 1999, he was appointed to the Court of Justice of the European Union as a judge of the Court of First Instance, and over the following 16 years, as a judge of the General Court, Sir Nicholas has taken part in many of that court's leading judgments, dealing with more than 1,500 cases, of which over 400 of those he was the reporting judge. So what better person to ask to come here to talk about Brexit and the opportunities, the challenges that it sets for the UK. So, with no further ado, I will invite Sir Nicholas to come forward and to talk about Brexit, a rocky path to sunlit uplands.
If I may, I'll just set myself up with a glass of water because I suspect I'm going to need it. And try not to pour it over the keyboard. Thank you very much, well, first of all, for being here, as they say, on the continent si nombreux. It's very impressive to have such a full room on an occasion like this. Thank you, too, for the invitation to come, and thank you, Paul, for that kind and generous introduction. It's often not an easy task to choose a subject for an annual law lecture. One's asked many months in advance ahead to indicate the intended subject, and then one's faced with the decision, should it be something topical, of immediate relevance, or perhaps something timeless, perhaps something that will be looked at some years ahead, picked up on a Google search perhaps, or perhaps by some yet-to-be-invented artificial intelligence legal algorithm, as being a repository of timeless wisdom on an issue of enduring relevance. This time, however, I had no such difficulty. When Edwin Parkes asked me last year whether I would be prepared to give this lecture, last June's referendum result was known. The new Prime Minister, had just announced the government's intention to proceed towards a meaningful Brexit as fast as it could do so. We now know, of course, that as fast as it could do so was not perhaps as fast as the government would have liked. It took a visit to the Supreme Court, following a first round in the High Court, to establish that triggering of the process for the United Kingdom to leave the European Union could not be done by the government without the legislative authority of Parliament. The Miller judgment in the Supreme Court has undoubtedly contributed significant new jurisprudence to what might collectively be called our unwritten constitution. It has clarified and arguably redefined the limits to the residual powers of Her Majesty's government under what is known as the Crown Perogative, and strengthened the sovereignty of the United Kingdom Parliament in relation to the government's conduct of international relations. Since these principles will be applicable not just to the EU treaties and to the manner of the UK's withdrawal, but also to every international agreement currently in force or which may be negotiated in future, if those agreements have effects on the rights or obligations under the laws of the United Kingdom, the Miller decision is clearly, in any event, an important one. So, given the role that the issue of UK parliamentary supremacy played in the Brexit debate, we should perhaps not be disappointed, at least with this first concrete result of the British Brexit referendum. Whether the other consequences will be quite so benign is perhaps more difficult to predict. Indeed, and I'm sorry to disappoint those of you who expected me to do so, I will not try to do so this evening. What I've decided to do instead is to discuss from a legal perspective, for this is, after all, a law lecture, but also inevitably, in some respects, from a political perspective, what will be involved in the process that is now underway following the Prime Minister's decision last month, with Parliament's legislative approval, to notify the European Union of the United Kingdom's decision to leave the European Union in accordance with the procedure laid down by Article 50 of the treaty. And I do so, even subject to this limitation, with even more than the usual degree of reticence, because we can now read almost every day and hear on the news almost every day assertions and predictions as to how those negotiations will go, the order in which subjects will be discussed, what each side is looking for, where the red lines are, and indeed what will happen if we reach the cliff edge of 2 years from the 29th of March 2017 without an agreement. And of course, this is all taking place in the context of a general election in this country, the second round of the presidential elections in France, followed by the elections to the Assemblée Nationale in France in June, and not to mention the German elections this autumn. So what I propose to do is to concentrate this evening on what legal constraints or guidance does Article 50, and indeed EU law generally, provide as to how those negotiations will proceed. What are the red lines that come not from political positions, but from those legal constraints? First, and I think it's important to understand this, Article 50 lays down a timetable that does two things. First, it fixes the moment at which the departing state is to cease to be a member of the European Union. Now, contrary to the impression given by many commentators, and perhaps as many of you may have thought today, that moment will not necessarily be the expiry of precisely 2 years from the date on which the United Kingdom delivered its formal notice to the EU, in other words, on the 29th of March 2019. The primary provision in Article 50 is that the date of departure will be that determined by the withdrawal agreement itself, or more precisely according to its terms, the date of the, and I quote, entry into force of that agreement. Now, as many of you who know international law will understand, international agreements regularly stipulate a date of entry into force that is different from the date on which the agreement is concluded. So therefore, it's only if no such agreement has been concluded within this 2-year period, and moreover that there's been no unanimous agreement between the United Kingdom and the 27 remaining EU states to extend that period, that the cliff edge will approach and the United Kingdom will fall over the edge into that metaphorical wilderness known as WTO world. And since there appears for the moment to be a determination on all sides that there will be a withdrawal agreement, it's safe, I think, to assume that it will be the date set in that agreement that will apply. And again, this is important to understand, there is no legal limit as to when that agreed date may be. It may be months, and legally could even be years after the 29th of March 2019. It could theoretically even be earlier, though given the realities of the negotiations that will be necessary, that's, I think, pretty unlikely. Indeed, as I shall explain, since it now seems to be envisaged that there will need to be a significant transitional period, or as the Prime Minister prefers to call it, an implementation period, between the United Kingdom leaving the European Union and the definitive coming into force of whatever will be the new long-term relationship between the UK and the EU 27, there will be a number of pragmatic arguments for some more conventional date for the United Kingdom to leave, such as the end of a calendar year, the end of the agricultural years. There are various, in a sense, more sensible dates that could be agreed rather than the arbitrary one of the 29th of March. Indeed, I think, so long as the ultimate destination and the certainty of departure is clear, I think even the most avid of Brexiteers could not reasonably oppose a short extension beyond the 29th of March if it eases the process of transition to that new relationship, whatever that will be. Second, Article 50 makes it clear that the primary mechanism for resolving the issues that necessarily result from a member state's departure is to be a withdrawal agreement, concluded on the one hand between the departing, though not yet departed, member state, and on the other hand, the European Council, comprising for this purpose the remaining 27 member states, and the consent of the European Parliament is also required. By contrast, Article 50 also makes clear that the withdrawal agreement is not the agreement by which the new long-term relationship between the diminished EU and the United Kingdom will be defined. And this is clear by the terms of Article 50, which make clear that the withdrawal agreement has to be negotiated having regard to that future relationship, but, or to use the words of Article 50, taking account of the framework for its future relationship with the Union. In other words, Article 50 requires the negotiations of the withdrawal at least to have proceeded towards defining the probable framework for that future relationship, but on the other hand precludes it from coming definitively to decide the detailed terms of that relationship. And that, as many of you will appreciate, is clearly sensible, having regard to the difficulties of which you would have read, of negotiating the sort of detailed trade agreements which exist between the EU and any other third state. There are also legal as well as practical reasons for the Article 50 being structured in this way. Legally, the powers of the EU are defined exhaustively by the treaties, and the relevant provision enabling the EU to make agreement with third countries, in general terms, is in Article 218 of the Treaty on the Functioning of the European Union. Now, the importance is that that provision envisages procedures that differ significantly from the relatively streamlined procedures in Article 50. Many of the international agreements that I've referred to already may require unanimity within the Council, whereas Article 50 merely envisages that the withdrawal agreement only requires a qualified majority within the Council. In certain cases, those agreements, because they will also involve what are called reserved areas for member states, will also require the agreement of national parliaments, and even in some member states, referenda or the approval of even regional parliaments. And I suppose many of you will be aware that the experience of the recent Canadian-EU trade agreement, which reminds us of how complicated and unpredictable this last stage can be. And of course, as I mentioned earlier, the negotiation of such agreements has frequently in the past taken decades and even longer, albeit, obviously, from a very different starting point that these negotiations will proceed from, namely a United Kingdom in which, at least at the moment, all our laws are already aligned with EU requirements, and where the grand repeal bill that is promised will, so it is said, continue most of those provisions relatively unchanged into purely UK law as from the date that Brexit takes effect. It therefore seems generally accepted that the withdrawal agreement, as well as including the elements necessary to resolve issues as to rights and liabilities arising prior to the UK ceasing to be a member state, these may include matters not only in relation to finances, financial obligations in relation to existing decisions, problems in relation, issues arising in relation to the financing of programs, agricultural, where the agricultural regimes broadly foresee a contribution period running up to, in the present case, 2020, 5-year programs. There's similar timescale in relation to financing of educational institutions. Many other areas, there will be programs already in place. And one of the issues to be resolved will be how the contributions to those programs and indeed the benefits from those programs will be adjusted to take account of Brexit. Very simple example, one could envisage the UK institutions being eligible up to some period, 3 or 4 years in the future, but with a corresponding obligation to contribute an equivalent sum to the funding of those arrangements. It's merely a theoretical possibility. I'm sure those who are familiar with these will be aware of others. Parenthetically, however, I know that the European Commission has already given instructions that, particularly when it comes to considering eligibility for various programs, account will have to be taken, and understandably I think to be taken, to the question of whether the participants in various programs will, and we're talking about future programs now, not rather than ones that are already running, future programs will be eligible and continue to be eligible having regard to Brexit. So, to the extent, therefore, that the agreement goes further than that, it will, I think, be fairly clear, and everyone accepts, that the withdrawal agreement can include some provisions that are necessary to ensure an orderly transition, as I've said, to whatever the new relationship will be. That clearly will be a delicate task. How far will those negotiations be able to proceed towards defining that relationship without, if you like, putting all the elements of that relationship in place? And the importance of that, of course, is that if you like, the competence of the European Union institutions to make transitional arrangements with a view to a future relationship will necessarily be related to the relationship between that future relationship and the present situation and the need for that smooth transition. But if negotiations have not proceeded sufficiently far, even to defining the framework for that future relationship, questions may well arise as to the legality of any transitional arrangements that are not, if you like, clearly relatable to an objectively defined future relationship. As I shall mention in a moment, the significance of that particular legal problem has recently been identified as one of the matters which will need to be addressed in the context of the negotiations. And I'll come back to that at the end of my presentation. The second question is how far those transitional, or in the Prime Minister's words, implementing arrangements can go, when in reality they may be extremely similar to the arrangements that, and effectively identical to, the terms of the provisions contained in the long-term agreement whenever these arrangement is finally concluded. The reason why this is a sensitive issue, and it's important that I should stress it, is that legislative competence is a sensitive and indeed a highly litigious subject in EU law. Interinstitutional disputes as to the competence of one or other institutions and as the procedures by which legislation should be adopted, agreements concluded, and so on, are common in the European Court. It's naturally right that there should be effective control in a situation where there is delegated powers, the member states delegate powers to the EU institutions, define the terms, it's natural that there should be a keenness to ensure that those powers are exercised in the ways that are agreed. Article 218, indeed, contains an express mechanism whereby any institution or member state can bring a proposed agreement before the European Court for a ruling on whether that agreement is in accordance with the treaties. It's highly probable, therefore, that if a dispute were to arise as to how far a withdrawal agreement can go in defining transitional arrangements with a departing state, that dispute could, and probably would, be brought before the Court of Justice, whether under Article 218 or possibly some other route. In this connection, one extremely likely candidate, in my view, for such a dispute may well be the issue of the continuing jurisdiction of the Court of Justice in relation to the subject matter of the withdrawal agreement. As I have indicated, I believe it is unavoidable that the Court of Justice will have jurisdiction to rule on whether the withdrawal agreement, and indeed the agreement determining the future relationship between the EU and the UK, is compatible with the EU treaties. But it will be a different question as to whether the Court of Justice should also have the competence to rule on the interpretation of the provisions of the withdrawal agreement, and indeed whether any such rulings would be binding on the UK if it does. This is inevitably a complicated area, and all the more so since we as yet have any little if any detailed idea of what those provisions may be. But two examples, I think, may help define the problem. First, as you will all be aware, one of the highest priority items on the list for the negotiations is the issue of what will be the rights of EU citizens currently residing in the UK post-Brexit and the corresponding rights of UK citizens residing in other EU member states. Whether this issue will be resolved separately or as part of an overall negotiation is a matter of lively discussion. What is less discussed is precisely what those rights are now and who will determine them post-Brexit. In one sense, that answer should be simple. The rights of the EU citizens in the UK and vice versa are currently determined by the Court of Justice. That's simply because the rights of EU citizens are derived from the treaties, and it's the Court of Justice that is the only arbiter of what those rights are. Moreover, the Court has to date jealously guarded that exclusive competence, as demonstrated by the various occasions when an international agreement involving the EU has been proposed, but then condemned by the Court as incompatible with the treaties, precisely on the ground that the agreement did not ensure the ability of the Court of Justice to be the final arbiter on issues of EU law. And the recent experience of the agreement for a unified patent court and the earlier case of the first proposed agreement on the EEA, the European Economic Area, that's the one that binds the EU with the three of the EFTA states, are just two examples of this determination on the court's part. How then will this principle be applied in the context of an agreement that, in some form, grandfathers the right of EU citizens in the UK and presumably reciprocally the rights of UK citizens in the EU 27? From the EU side, at least, that agreement would presumably be given effect as an instrument of EU law, from which UK citizens would be able to claim their rights, even though they were no longer EU citizens, in the states in which they reside or when they move throughout the EU. And in the event of a dispute before the court of one of the EU 27 as to what that agreement provided for, in other words, a question of interpretation, it may be presumed that a national court, if in doubt, could, and in some situations would have to, refer that question to the Court of Justice under Article 263 of the TFEU. And that would be so if, as will be most likely, the agreement does not purportedly, exhaustively to set out these rights in specific terms, but does so instead by way of reference to what those existing rights already are. In those circumstances, there can be little doubt that the Court of Justice would see the definition of what constitutes the existing rights of EU citizens under the treaties as developed not only in the case law of the Court of Justice to date, but even as may be developed in future interpretive rulings as to what the existing treaties require, as a matter entirely appropriate for a national court to consider, and indeed to refer to the Court of Justice when necessary. Indeed, as some of you may know, there's an obvious parallel here to cases where the Court of Justice has accepted requests for preliminary rulings from national courts, where the issue before the national court was not a matter of EU primary law or secondary law, but one of purely national law, but where the national law in question had been formulated so as to be identical to EU law in the field in question. There's one recent example in relation to competition law in Lithuania, where the Lithuanian legislator had modelled his law entirely on EU law with the intention that it should be the same. And so, even though all that was an issue before the national court was an issue of Lithuanian law, the Lithuanian court asked the Court of Justice what would the EU law interpretation of those provisions be, because we will rely on that in order to interpret our national law. We arguably will have exactly that same situation in the United Kingdom in a way, if, as the government appears to suggest, UK competition law, which already is expressed in terms identical to the corresponding provisions in the EU treaties, continue to be expressed in such terms and with the obvious intention that the rules be the same. A second example, I think, can be taken from a different field, commerce. There is increasing recognition in some sectors now that EU law, and thus the role of the Court of Justice as final arbiter of what that law means, will have to be accepted not only for companies trading goods with Europe, but also in the financial services sector in particular, even for the way that financial services are provided in Europe, but involving activities in this country. It seems, and I don't pretend to be an expert in the financial service, that this is leading to an increasing recognition in the financial services sector that it may well be essential, at the very least in the context of the transitional arrangements, to accept a role of the Court of Justice as the de facto, if not de jure, final arbiter of what regulations will apply to that sector in the United Kingdom. And it's here that we come to what is essentially a political problem, and what, in my view, is an entirely unnecessary one. The government's pronouncements as to its intentions for Brexit have focused, in my view mistakenly, on the supposed desire of the British people, as expressed in the June referendum result, to escape from the jurisdiction of the European Court of Justice. Personally, I doubt that that factor was even in the minds of a significant fraction of the British people. And indeed, even a moment's informed thought makes it clear that singling out leaving the jurisdiction of the Court of Justice from the basic idea of just leaving the EU is to make a distinction without any difference. The Court of Justice has no jurisdiction other than to give rulings on the correct interpretation of the EU treaties and the EU secondary legislation, such as regulations and directives, and to rule on the legality of the acts of the EU institutions or indeed of EU member states, if they breach EU law. The Court of Justice does not make new law, it merely interprets what the member states have agreed, either in the treaties or in that secondary legislation. And even where that legislation has been adopted only by a qualified majority of member states, that possibility has only arisen because, whether in the treaties or in some other decision, the member states have unanimously agreed that this should be the case. In short, every act of any of the EU institutions, indeed the whole body of EU law, can be traced back directly to a decision of the United Kingdom government of the day that either agreed expressly to that measure or at least agreed that the measure might be adopted even though, on that particular issue, it might be in a minority. The Court of Justice, in every one of its rulings, has therefore never done more than simply interpret, and where necessary give effect to, an agreement to which the UK fully signed up at the relevant time. From the moment that the UK ceases to be a member of the EU, of course, EU law, as it has been applied in the United Kingdom from 1973, will cease to constrain the actions of UK citizens and companies in the way that it did, unless, of course, they choose to be so constrained, for example, because they wish to sell their goods to the EU or to provide services to EU customers. Moreover, if there are residual rights and obligations from those agreements on our behalf that result from the period when the UK was a member state, then it seems not to be unreasonable that the Court of Justice should continue to determine, when necessary, precisely what those rights and obligations are. In that connection, as Paul has mentioned, one of the areas I know particularly well is competition law. Competition law concerns agreements between companies known as cartels, whereby they try to fix prices, limit output, and generally do the consumer down. The EU law and activities of the Commission ensure now that these agreements are increasingly detected and fines are imposed. But what is more important, the participants are liable to compensate those who suffered loss as a result of those agreements. And what one is there seeing is litigation that typically is brought by which a group of plaintiffs will bring proceedings seeking damages for infringements of EU competition law that took place years, even decades, after the time the action is brought. One can say, well, those rights exist only because of EU law. The terms and extent of those rights are determined by EU law. What then is the logical reason for depriving the Court of Justice of the ability to pronounce on what those rights are, should any question arise as to what the law actually is? It seems to me not unreasonable that the court should not be able to expect that the court, it seems unreasonable not to expect the court to be able to do so. Of course, new rights and obligations may well arise under the withdrawal agreement. Indeed, we must all hope that we do, otherwise we will find ourselves falling over the edge of that metaphorical cliff on the 29th of March 2019. But what about those new rights? Is it necessary that the Court of Justice should determine these? Certainly, it is the case that international agreements concluded by the European Union with third states do not automatically give the jurisdiction to the Court of Justice to give jurisdiction to the Court of Justice the right to interpret them. Such agreements may expressly give the Court of Justice that jurisdiction, one example being the EEA agreement, whose provisions in effect make rulings of the Court of Justice effectively binding also on the EFTA state that are parties to that agreement. And the Court of Justice will also necessarily have jurisdiction to apply and interpret and apply whatever acts are adopted by the EU institutions to give effect to whatever agreement is made. There are many examples of this, particularly in the field of WTO agreements, where after the EU entered into the WTO agreements on behalf, the Commission entered into the WTO agreements on behalf of the EU, there was then a separate act giving effect to that within EU law. So, in my view, there should be no reasoned objection in principle to a withdrawal agreement, which in some way or other is liable to interpretation by the Court of Justice as an arbiter of its meaning. That's not necessary, of course, and other dispute resolution mechanisms can be envisaged. And indeed, reassuringly, in its negotiating mandate, the Council indicates that it's open to that, and I'll come to that in a moment. What, however, there is what I see as unreasoned objection to that possibility. Sir David Edward, the UK's former judge at the Court of Justice, recently referred to the misleading insistence that London will be able to leave the jurisdiction of Europe's top court. He said that he was astonished at what he was described as the invincible ignorance of Prime Minister Theresa May and Brexiteers, who say that departure will secure British sovereignty from EU courts. As he put it, you can escape the jurisdiction of the ECJ, but you've got to comply with EU standards if you're going to export into the EU. And as I said, it goes much further than that. But my real concern is that unnecessarily the government, or at least certain of its members, is building an artificial obstacle into the negotiating position, which will make it significantly more difficult for the parties to reach a favourable outcome in the negotiations. Red lines may be understandable, if not wise, where they touch on a matter of real economic or political importance to the interests of the United Kingdom. But escaping the jurisdiction of the Court of Justice is a chimera, or as Google defines it, a thing which is hoped for but is illusory or impossible to achieve. Let me now turn to a further legal issue, much discussed immediately before the Brexit vote in Parliament, not least because of what has become known as the Three Knights opinion on this very question. In short, if the negotiations go badly, so badly indeed that there's a reasonable political case for concluding that the outcome of the Brexit process is markedly different from that which Brexit campaigners promised it would it be legally possible for the UK to change its mind and withdraw or revoke in some way the Article 50 notification so that we remain a member of the EU after all? And if there is such a possibility, can it be done unilaterally, or would it require the consent of the rest of the EU as well? The arguments in favour of the legal possibility of revocability are, in my view, not likely to be dismissed, particularly since a number of those closely involved in the initial drafting of Article 50 claim that this was precisely intended to be the result. These include not least Lord Kerr, who, as Sir John Kerr, was the Secretary-General of the Constitutional Convention in the mid-2000s, when the text of what is now Article 50 first appeared. There's also the view of Sir Alan Dashwood, a former member of the EU Council's legal service, and last but by no means least, Monsieur Jean-Claude Piris, a former Director General of that very same service. The argument, in effect, has two parts. First, it is said that Article 50 is silent on the issue, and that in accordance with general principles of international law, not least the Vienna Convention on the Law of Treaties, notices to withdraw from a treaty can be rescinded before they have taken effect. Secondly, after Miller, it is said that the constitutional requirements of the UK, which are a prerequisite for a valid notice to withdraw to be given, require not only a parliamentary authorisation to give the Article 50 notice at the time that it is given, but the continuation of that willingness up to the date of actual departure. In other words, if Parliament were to direct that the notification be withdrawn, that notification and the departure would no longer be in accordance with the UK's constitutional requirements, and it would follow, therefore, that the withdrawal would be or become ineffective. Now, as many of you may know, this issue was not in fact tested before the High Court or the Supreme Court in Miller, because it was treated as common ground between the parties that an Article 50 notice once given could not be revoked or withdrawn. No doubt neither side was keen to see the issue of revocability referred to the Court of Justice, which, as the final arbiter on all matters relating to the interpretation of the treaties, would have had to give a ruling on the question, which would probably have been, certainly after some months and possibly longer than that, which would be a further delay before which the whole process could be started. However, it seems that issue is not going to go away so easily. As some of you may know, proceedings have been commenced in the Irish High Court with a view to that court referring the question of revocability to the European Court of Justice. And I understand that Mr. Justice Peter Kelly has fixed a hearing for the 31st of May to determine whether the Irish courts have jurisdiction to hear such a case. The arguments that they do so involving the implications of Brexit on relations between the Northern Ireland and the Republic, and in particular for the Good Friday Agreement. Given the understandable sensitivities in Ireland of the implications of Brexit for the whole of the island of Ireland, I would hesitate to predict with confidence that the Irish courts will decline to hear the case. And if they do hear it, then the issue may almost certainly come before the Court of Justice. Let me then finish by adding some news, which I might almost be said is hot off the press. If nothing else, you'll be able to say that you heard it here first, in line, I'm sure, with the aims of the law faculty of the Open University. This very week, the EU 27 are settling the negotiating guidelines for the Brexit negotiations. Tomorrow, they will be considered by the General Affairs Council of the EU and then adopted on Friday at the meeting of the European Council attended by the heads of state of government of the EU 27. Those guidelines, not surprisingly, address the key issue of the future involvement of the Court of Justice, and indeed other key institutions, even after Brexit. 2 points are worth mentioning in the light of what I've just described. First, the guidelines stress the fact that transitional arrangements as a bridge towards the future relationship may be envisaged to the extent that they are legally possible. That's the phrase used in the negotiating position. That, in my view, constitutes a clear flag that the Court of Justice will remain competent to decide what may and may not be included in any withdrawal agreement and what the limits will be in respect of those transitional arrangements. The guidelines also go on to stress that, draft guidelines, because they're due to be adopted tomorrow, any such transitional arrangements must be clearly defined, limited in time, and subject to effective enforcement mechanisms. Should a time-limited prolongation of union acquis be considered, union acquis essentially the current state of European Union law, this would require existing union regulatory, budgetary, supervisory, judiciary, and enforcement instruments and structures to apply. In other words, what the Council is saying, if these transitional arrangements are going broadly to correspond to what we have now until the new relationship is defined, then that part of that is going to have to be the involvement of the Court of Justice in deciding what those provisions are. And as I've said, if the provisions of the transitional arrangements are effectively identical to what is there already, one can understand the inherent logic of that. In other words, to the extent you want the transitional arrangements to resemble the present position, you must accept the continuing role of the Court of Justice. Later in that same draft document, the following is said: arrangements ensuring legal certainty and equal treatment should be found for all court procedures pending before the Court of Justice of the European Union upon the date of withdrawal that involve the United Kingdom or natural or legal persons in the United Kingdom. In other words, merely because the United Kingdom has left doesn't mean that the United Kingdom and its citizens will not be able to go to the European Court to challenge decisions or bring any proceedings in the way that they can at the moment. And it continues, the Court of Justice of the European Union should remain competent to adjudicate in those procedures. Similarly, it goes on, arrangements should be found for administrative procedures pending before the European Commission and Union agencies on the date of withdrawal that involve the United Kingdom or natural or legal persons in the United Kingdom. In addition, arrangements should be foreseen for the possibility of administrative or court proceedings to be initiated post-exit for facts that have occurred before the withdrawal date. So not merely if there's something already happening, will your rights continue, including control by the Court of Justice, but even if something happens, new proceedings are started that relate to what happened before the United Kingdom left, then arrangements will need to be made, and those arrangements are clearly envisaged to involve the continuation of the Court of Justice. It then goes on to say, and now addressing the question of dispute settlement provisions, both in the withdrawal agreement to the extent it's not merely a continuation of the acquis, but even in the new relationship, the withdrawal agreement should include appropriate dispute settlement and enforcement mechanisms regarding the application and interpretation of the withdrawal agreement, as well as duly circumscribed institutional arrangements allowing for the adoption of measures necessary to deal with situations not foreseen in the withdrawal agreement. That last provision seems to me an extremely sensible one, given the difficulty of foreseeing all the problems that are going to arise. This should be done, however, the Council adds, having regard to the bearing in mind the European Union's interest to effectively to protect its autonomy and its legal order, including the role of the Court of Justice of the European Union. In conclusion, therefore, I do not know whether Brexit will lead to the sunlit uplands promised by many pro-Brexiteers, including cabinet ministers who perhaps should have known better than to promise what they could not guarantee. But as anyone who has walked in the Alps knows, sunlit uplands can normally only be reached after a steep ascent up a difficult and rocky path. Getting there is hard enough, even without bringing down boulders that may block the easiest path altogether. Obsessing about the Court of Justice, and moreover doing so unnecessarily, is not going to help. It will only hinder. Thank you very much.